Hi, folks. I'm Denise Howell. And next up on This Week in Law, delve with us into the multiverse, won't you? James Daly is with us, Sarah Pearson as well. We're going to talk about the law of various fantastical realms, as well as real law that applies to those who create the fantastical realms. All next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CACHEFLY.com.
This is Twill, This Week in Law with Denise Howell and Sarah Pearson, episode 326, recorded November 6, 2015. Rocket's defamation suit. This episode of This Week in Law is brought to you by FreshBooks, the super simple cloud accounting software that's giving thousands of freelancers and small businesses the tools to save time billing and get paid faster. Try it free at freshbooks.com/twill. Hi, folks. Welcome to This Week in Law. I'm so glad you're here with us today. I'm Denise Howell. I'm here with my co-host, Sarah Pearson. Hi, Sarah.
Hey, Denise.
And we feel like lots of heavy stuff has been happening in the world lately. We just had Halloween and Day of the Dead. Obviously, we've got plane crashes and school shootings and all kinds of other stuff that are taking up a lot of people's cycles these days, not to mention being almost in an election year. And I figured we could use a little levity. And we're going to offer that up for you on this episode of This Week in Law. We have the perfect guest to provide that with. Joining us once again on the show is James Daly. James is the author of a wonderful blog called Law and the Multiverse. Welcome back, James.
Thank you for having me.
James makes the circuit at Comic-Con and other such festivals because what he does at Law and the Multiverse is examine the legal ramifications of fictional scenarios that play out on TV and in comic books and in comic book-oriented movies. How would you define sort of what you think is on topic for your blog, James, and what's off topic?
Well, I try to stick to the fictional side of things rather than the real-world part, although there are many important legal issues surrounding comic books in the real world, with copyright and trademark being only the most obvious. But so what I tend to stick to is what are the thinking through the legal problems that are presented in comic book type situations, because in most comic books they take place in the real world or something very close to it. It's the real world except there are aliens. It's the real world except there are mutants or whatever. And so I try to think, well, that means the legal system works about the same as it does in the real world, and so we should be able to use that as a jumping-off point for some good discussion.
All right, and it does seem like the real world and the comic book world do have their collisions from time to time, whether it's law playing out in fictional scenarios or fictional scenarios tickling the funny bone of members of the Supreme Court, as we saw earlier this year. I think we'll start off the show by discussing the Kimball versus Marvel copyright. Actually, it's more of a patent decision. Thanks so very much. All right. So in Kimball versus Marvel, which came out last June, there was a fairly straightforward dispute involved. It involved whether you could contractually agree for parties to pay royalties on a product after the patent for that product has expired. The product in question was a device from the Spider-Man, well, not from the Spider-Man universe, but that would allow one to role play as though they were in the Spider-Man universe. It was a thing that you would wear on your hand that would shoot out faux webbing. So that patented device had a contract that went along with it that enabled the inventor to continue to receive royalties. And this went all the way to the Supreme Court to determine whether a decision that was that came down in the 60s that said, no, you cannot agree to pay royalties after the expiration of a patent term, whether that should be set aside. And the court decided, no, we're going to go ahead and follow that law that we made in the 1960s. There's no reason to set it aside. But one of the reasons the case was so notable is it was just rife with Spider-Man references. And Justice Kagan really had a good time as she was writing the opinion in bringing up such things as with great power comes great responsibility. I'm misquoting that. But you wrote about it on Law and the Multiverse, James. And I'm wondering what your take is on the decision and on the Supreme Court wading into the world of Spider-Man.
Yeah. Well, in the real world, one of my main areas of experience and I hesitate to say expertise, but at least the focus of my experience and writing has been intellectual property and especially patents. So this really sort of a natural fit to write about, even though it's a real world case and sort of a little bit different than what we normally write about on the blog. But quite a few people asked what I thought about it, so I thought, well, okay, I'll write up a post. And in terms of the opinion itself, well, I disagree with it. I think that the decision that they upheld was wrongly decided in the first place, and it should never have been decided that way. And certainly there were many opportunities since then for the court to change their mind, and they had decided not to take those cases in the past, and then finally they took this one. And what they did was they decided in favor of the second largest media company in the world against an individual inventor who the facts seem to indicate Marvel, now Disney, had basically ripped off, that he had approached them about licensing his invention. They said no, and then shortly thereafter came out with their own toy that was pretty much the same as what he had showed them. Then he sued for patent infringement. They settled, and then the royalty payments happened for a while, and then Disney's lawyers eventually realized, oh, wait, we don't actually have to pay this person because the patent is expired. So they wanted to get out of the royalty agreement, and they fought it all the way to the Supreme Court and ultimately won. So it's not really David. I mean, it's a David versus Goliath story, except in this case, Goliath wins pretty soundly. And so while the references to the Spider-Man and so forth are fun or cute, they don't really fit the facts of the case. The facts of the case is that this guy who came up with this toy that apparently sold pretty well and thought he'd come up with something cool ended up getting trounced by a giant company. So I don't know. I think maybe if the case had gone the other way, then there'd be maybe some room for that kind of levity. But as it was, it struck me as a little tone deaf, to be honest.
Yeah, and the court was so concerned here with the principle of stare decisis, and that is a legal term, a Latin term that refers to courts honoring prior judicial decisions, that they have weight and authority, and not undoing them except in cases where it seems important from a policy standpoint to do so. So it's a balance that courts, especially the Supreme Court, try to reach in exactly how much authority they're going to give older decisions and whether those principles carry forward. And what I was unclear about in this case, I haven't dug too deeply into the facts, is when exactly this contract that permitted the royalties came into existence. My perception and recollection from when this came down in June is that it actually predated the decision that the court decided to follow here in the 60s, that the contract dated all the way back to the decade prior. And so the principles of stare decisis that the court was trying to preserve, the court's justification mentioned here in this case was, we want to give people the ability to order their affairs by knowing that laws that exist when they enter into contracts are going to continue to govern those contracts in the same way. But here, if the contract predated the decision, that wouldn't be so much a concern. Do you know, James, whether it did?
The decision that they were ultimately upheld was Brulot v. Tice, or Tiss, I'm not actually sure how it's pronounced, which is from 1964. The contract, which is in this case was a settlement agreement, was in or around 1997 or so. So
okay.
So yeah, the agreement was made well after that case, but right. Apparently the attorneys who wrote the contract weren't aware of it, and so they were paying royalties even after the expiration of the patent, and then suddenly realized, well, wait, we don't actually have to do that. So it doesn't speak very well to Marvel's attorneys that they wrote the settlement agreement that way in the first place. But anyway,
right. I don't know why I had the 50s in mind. That may be when the product first came into being.
Maybe in terms of stare decisis, I think that in this case there were good reasons to overturn the prior decision. It was widely considered a bad decision in terms of the legal aspects of it, but it was also very widely understood to be a bad policy from an economic point of view, that in terms of preventing people from structuring their patent licenses that way was bad for the market. Well, and people can disagree about the economics of the law, but the point is that at least from one side, there were good reasons to think that that the decision should have been overturned, and they decided not to, which personally I disagree with. But people don't come to the blog to read my opinions about patent law. They come to the blog to read about comic book hijinks. So this was a kind of a rare instance, though, when it was so on point that it seemed like I needed to talk about it.
Yes. Sarah, do you have any opinion one way or the other about whether parties should be able to contract for royalties that would continue to be paid after a patent expires?
Well, I think it's really, this decision, at least on its surface, I've never read the full opinion, and I was thinking after this conversation I really should, because it's, on its face, it seems kind of like a crazy thing to say that you can't contract to pay royalties beyond. I don't know why you would. Like, I was thinking the same thing as James, is why would the Marvel lawyers agree to, it does seem just like bad lawyering to agree to pay royalties beyond the patent when you legally don't have to. But if they did, usually there's this principle that you can contract away most rights that you'd, unless it's First Amendment or something. So it's just kind of interesting because you don't see that same corollary, I don't think, very often, at least, applied in copyright. People impose contracts on public domain works all the time. I think there are a lot of people that object to that practice, but as far as I know, I don't know that is legally objectionable as long as it's framed as a contractual obligation as opposed to being anything rooted in copyright. So it's just, to me, it just seems a little bit odd. But on the other hand, like I said, I'd like to read the full opinion and kind of dig in a little bit. But in theory, I guess I kind of like the idea that, the patent ends at 20 years and that's when the end of your monopoly is. And but I don't know, it just doesn't seem like we don't think of intellectual property that same way in other domains. So
yeah, it leads to weird situations. So suppose you have 5 years left on the patent term, and you're going to make a license, and you say, all right, well, we want $10 million to license this patent to you because it's worth a lot of money. It's a very big deal on the market or something. And the person who wants to license it says, well, we only get about $1 million in a year that we have to play with this, so we'll pay you $1 million a year. Well, there's only 5 years left on the term of the patent, so they'd only get $5 million, not 10. Well, one way you could structure the license is say, well, you'll just pay us $1 million a year for 10 years. Well, under this decision, that's not allowed. As soon as the patent term is up, time is over. So either the deal doesn't get done, or it pushes it in weird ways. Like then they have to go to a bank and they get a loan that lets them pay $2 million a year for 5 years. People work around it, but they work around it in weird ways that make contracting much more complicated than it has to be. And I go into more detail about all the weirdness that it causes, but that might be getting a little bit too technical.
Yeah, no, it does seem like just the arbitrary patent term at that point is interfering with the party's ability to structure payment however they'd like.
Yeah,
they always have to bear that in mind.
Yeah, it makes a certain amount of sense on its face. I mean, it seems weird that people should be able to extract payments for something that they can no longer have the legal right to exclude other people from doing. But that wasn't true when they made the deal. When they made the deal, they had that ability, and so maybe they should have more freedom to operate how they want to. But in any case, it's getting back to the opinion itself. People talked about, Kagan is so cool. She did this thing. It's funny. It's like nerdy sort of thing. Well, a dirty secret of the Supreme Court is that very few of Supreme Court opinions are actually written by the justices anymore. There's they're almost all written by their clerks these days, in large part. So it could very well be that one of Kagan's clerks is a Spider-Man fan, but she herself may or may not actually be. It's hard to say, unfortunately. But there's been some really interesting computational linguistic analysis of Supreme Court opinions that shows that for the past few decades, ever since they really started relying on their clerks pretty heavily, that most of the opinions probably get written by other people anyway.
All right. Well, I think you just gave us our first MCLE passphrase for this episode of This Week in Law, nerdy clerks, because clearly the Supreme Court has at least one of them.
Yeah.
Let's move on and talk about some of the kinds of scenarios that you write about all the time at Law in the Multiverse, James. I've lumped these. These are all sort of actually, before we get to that, let's do an ad first, and then a bit more substantive law about comic books, about real world law as it relates to fictional scenarios. So first, let's thank our first and only sponsor for this episode of This Week in Law, which is FreshBooks. FreshBooks, if you are a freelancer or you run a small business, the chances are that your very least favorite part is rummaging through receipts, trying to keep track of your expenses, creating, formatting, and sending invoices, and the worst, tracking down customers who don't pay you on time. FreshBooks is the super simple cloud accounting software that's giving thousands of businesses like yours the tools to save time billing and get paid faster. I use FreshBooks in my law practice, and thank goodness I do, because if it weren't as easy as FreshBooks makes it, I would be in that awful situation of getting invoices out far too late, far too after the fact, simply because of it's not an easy or fun task unless you're using FreshBooks. With FreshBooks, it couldn't be easier, even if you're not a numbers person. For me, I can create and send invoices in minutes. You can set it up now that you can get paid up front. You can request a deposit in FreshBooks. So if you're the kind of person who needs to get a retainer before you start getting the work done, you can do that. You don't have to cover costs out of pocket or wait till the end of a project to get paid. You can organize your expenses easily. It's easy to track your time almost instantly, even on mobile devices. And with their automated late payment reminders, you can avoid those awkward emails to late paying clients. With FreshBooks' automated customer reviews report, you can see all of your reviews in one place, then easily post them on your website. You'll wonder why you didn't start sooner. If you have questions, help is free forever, and you can always count on FreshBooks award-winning support rock stars to go above and beyond whenever you need a hand. Getting started is simple, and it's totally free for 30 days. Go to freshbooks.com/twill, and don't forget to enter This Week in Law in the How Did You Hear About Us section. Start your 30-day free trial today. Thank you so much, FreshBooks, for supporting this episode of This Week in Law. All right, let's move on to, again, some of our law affecting the ability to enjoy the fictional world of comics and otherwise. And some of these works have been subject for decades to censorship and discrimination, so I wanted to touch on some of those issues. All right, so we just celebrated the 61st anniversary of something called the Comics Code. This went into place many, many years ago. The Comics Code Authority was founded and implemented a series of rules, regulations, and guidelines, including a seal of approval that basically censored the entire world of comics. People were quite concerned about the influence that they would have on America's youth. So this is no longer in place. In fact, the Comic Book Magazine Association recently donated the CCA seal to the Comic Book Legal Defense Fund. So they are now they now have the legal rights to that seal, and the seal is now defunct. But for many, many decades, a panel would vet comics. There were rules that that they would have to follow in order to gain the seal of approval, and only comics with the seal of approval would find themselves widely available for commercial sale. So it was a big deal, and it's something that we've seen shift over the years. I'm wondering, James, what you think about the world of censorship today, because it has not gone entirely away.
No, it hasn't. And as I think we'll talk about later, there are still some areas where comic books and comic media are censored in other ways, not necessarily by a formal organization, but they can be either de jure, sort of legally, explicitly legally, or they can be censored by schools acting independently. They're still part of the government, public schools anyway, but they're acting on their own, not as part of a national government policy, but it's still a government action. So while we don't have that same kind of structure as in the code era, comics are still something that comes under fire quite a lot, partly because they're sort of seen as inherently aimed at children, and so we have to be concerned that they might be corrupting the youth, but also because they're visual, and that leads to lots of complications, because there are many things that people are more okay with being in text that they're not okay when it's in a visual medium.
Yeah, that's an interesting point. As the Comic Book Legal Defense Fund points out in its post commemorating 61 years after the formation of the Comics Code Authority, there are several genres of comic books that used to exist that never really bounced back from the need to comply with the rules that were put into place. Some of the rules were very strange. They involved, not using the word terror or horror in the title of the comic. Depictions of evil could not be alluring. Horror comics, crime comics, they point out that Jungle Girls and Westerns never really were able to survive the code. So it really had an impact on the landscape, the historical landscape, and comics as they developed over the years. Sarah, what are your thoughts?
Well, I just thought this was fascinating because I did not know this history at all. And it just struck me because so many things come, like history repeats itself. And this is one of those where you hear these exact same arguments about video games you have now for, I guess, like 30 years. I remember growing up, there was a big outroar, and you still hear it about, what are these violent video games doing to our kids and blah, blah, blah. I don't know. It's really fascinating that it's this exact same thing, just a different medium. And I didn't know this history, so I thought it was really interesting.
Yeah, and I encourage folks to check out this post at the Comic Book Legal Defense Fund. You can find it and all the other stories that we are discussing today at tagpacker.com/user/thisweekinlaw. All right, let's talk about a couple of other comic censorship-related issues and fiction censorship-related issues. First of all, in Japan, we're coming up on the Olympics taking place there in 2020. And I don't know if there's a relationship between that and what we're about to discuss or not, but a UN Special Envoy on Child Protection has made a request to Japan urging the country to ban particular extreme child pornographic content, even if actual children are not involved. So we're talking about manga. Is that how I say that, James? I've always said manga, but I don't know if people say manga.
I've heard it both ways. Honestly, I'm not sure which is correct. I'm more of a Western comic book reader myself, so I wouldn't be the one to ask about that.
Right, and the issue here is whether anything that is depicted in Japanese manga and anime could be considered child pornography. Child pornography should actually, by most legal definitions, involve a child and not an artistic depiction of a fictional character. So technically, there's no pornography involved, no matter what the imagery involved is. And I think there are some fairly graphic publications that the UN Special Envoy probably had in mind in raising this. So this is something that has not been played out other than just as a request to the Japanese government to take further steps. But it's something to keep an eye on as the Olympics approach and more global visitors get involved in Japanese culture. Sarah, any thoughts?
Well, no, I was just wondering whether or not that rule is the same in the U.S. Is child porn only with considered to have actual people in it, or is it possible to have, for example, cartoon child pornography in the U.S.? I don't know the answer, but it'd be interesting.
My understanding is that it is depictions of actual people.
Okay.
There's a problem where, well, what if the drawn imagery was made using a real person, a real child, as a model, whether they were nude or not at the time, or otherwise engaged in a sexual act at the time. Then it's indirectly exploitative if they weren't engaged in a sexual act or nude, and it's potentially directly exploitative if they were. And so that's kind of the argument that's being made. Well, one of the two arguments being made by proponents of these kinds of bans. One is that underlying all of this is some degree of direct, or at least potentially underlying this is some degree of exploitation of children. And then the other argument is that it still contributes to the market for real, quote, real child pornography. That the fact that this sort of drawn stuff is available still means that people will want, quote, the real thing. How true all that is, I don't know. I'm not an expert in this area, and I don't know much about its production or certainly not whether or not it affects the market. But those are the arguments being made, and I don't know. I think that it would be possible to craft a law to say, well, what's illegal is using a child, exploiting a child to produce that stuff, not necessarily the thing itself. Because what if the thing was made just entirely from someone's imagination? They'd never seen a nude child, and they were just imagining the whole thing, and decided to draw it up. Well, arguably, there's no child being hurt in that case, so it's difficult. I think that in the U.S., the First Amendment is quite strong, some of the strongest protection of expression in the world, and I think that in the U.S. we tend to say, nope, there really has to be direct evidence of a child's involvement before we would say that that's obscene.
Right. I think what the Comic Book Legal Defense Fund may be concerned with, and the person that they're quoting, who was also, he spoke to The Guardian for its article on the UN Special Envoy's recommendations, that is Japanese culture expert Dan Kanemitsu. And what they seem to be concerned about is just the differences in interpretation of artistic styles. He writes, many male and female artists in Japan draw characters in an art style that looks childish to Western eyes. Therefore, it is a rejection of an art style popular in Japan. So I think what they're getting at here is not so much the graphic nature of the illustrations, although that's certainly one thing to discuss, and we have been, but just whether the art style itself triggers people to think, oh, children are being exploited because the characters in this book look young. And so I think they've got their eye on that and are
well, that's certainly one
cautious.
issue, but it's slightly disingenuous because, yeah, that's true about the art style, and certainly I think we should be careful to say that just because a character looks young but is plainly in the way they are written and the way they act and all that kind of thing is clearly of an appropriate age, that we shouldn't attack that necessarily. But it is also the case that there's definitely art of this kind where the characters are very explicitly underage. It's not just that they're drawn to look young, they are in fact young. Or that while they're described as, oh no, they're 18, but they act like a child, they're drawn as a child. Like there's a difference between art style and art style as a fig leaf. And so now, whether or not that means that it should still be bannable is another matter entirely. But I think that the commentator that you quoted there was not being entirely forthright about the nature of a lot of that.
Right. All right. Let's move on to Captain Underpants, because if you're a parent in the United States, odds are Captain Underpants has been a part of your life. And for some parents, I guess. All the parents that I know, Captain Underpants has actually been not taught in the schools, but available in school libraries. And so, definitely a part and parcel of their child's growing up in about 3rd or 4th grade. But in Michigan, there was an issue because the latest episode or installment of the Captain Underpants novels, I have no idea how many of them there are now, but lots. The latest one has a bit of a footnote at the end, and I don't want to spoil it for anyone if you haven't read through each and every one of the books, but there was a note at the end, a fictional note at the end, that one of the protagonists had grown up to be an artist living with his domestic partner, Billy. So this caused some alarm to the Arborwood Elementary School parent-teacher organization as they were preparing for their book fair. Because for folks who haven't participated in a book fair for a while, how this tends to go is books are set up in an appealing way at the school. Kids are sent in with a little bit of spending money and able to buy their own books without parental supervision. So the PTA actually reached out to the parents here and decided, we're not going to put that one on sale because some parents might choose not to have their child buy that book, and they're not going to be there to say no. So I guess this is not the first instance where author Dave Pilkey, who writes the Captain Underpants series, has been challenged. In fact, the Comic Book Legal Defense Fund points out that Captain Underpants has been repeatedly on the American Library Association's most frequently banned books list for its unsuitable content. For anyone not familiar with the books, I only really remember the first one and the premise that the boys hypnotize their principal and he becomes one of their comic book characters and gains the superpowers that they have come up with fictionally in the drawings that they've been doing. So Captain Underpants continues to be controversial, I guess, and the kind of thing that is subject to, this was no ban on the book. It was just a choice whether to make it available at a book fair. So what do you think of this, James?
Well, I think that I think that in some ways it still is a ban because for many students, the book fair is one of the very few places where they can purchase books of their own, that they may not be taken to bookstores or libraries outside the school frequently. So if the school simply says, well, we're not going to carry it in the library, we're not going to buy this particular Captain Underpants volume, and we're not going to carry it in the bookstore or at the book fair, for many students that is a de facto ban. The fact that they could buy it elsewhere doesn't really help much, because the one public place, the publicly made available place where they can buy it or check it out, doesn't carry it. Now, this is not to say that libraries have to carry every book under the sun. That they certainly can make decisions about what's appropriate or the best use of their resources. But when it's being made strictly on moral grounds, and maybe questionable moral grounds at that, I think that this is still a ban of a kind. Even if a student could technically bring it to school and not be gotten in trouble for simply possessing it, although I suspect that most elementary school students would have fairly little opportunity to read a book in school. If they just pull out a book and decide, I'm not going to pay attention to class, I'm going to read this book. So the fact that it's not banned to possess it, possession isn't banned, I think that's not much of a difference from what they've done here. So no, I think the ban is still a reasonable term to use in a case like this, and so is censorship, because it's important to remember that this is a public school, and so it is the government making this decision, that the government will not make this book available to students. And again, they don't have to make every book available to students. They can make decisions, but in this case, the criterion that they were using to make that decision was, I think, kind of suspect.
Yeah, I would have to agree with you. It seems a strange place to draw the line when, at least at our public school library, the entire series is available. I don't know whether this particular school in Michigan decided this book was not going to be available in the library as well or not. Sarah, any thoughts?
I mean, I agree. I think it's appalling, actually. But I am curious about, this makes me wonder about where the First Amendment line gets drawn, because if I read correctly or remembering correctly, it was the PTA that made this decision. And I wonder whether they're technically considered, because that's parent-led, is that technically still considered action by the school? And if so, doesn't it then become a First Amendment issue? But I don't know the answer. If either of you do, I would love to know, but that's what it made me think about.
Yeah, it's a good question. I'm sure it's come up before, because PTAs often take actions that seem to be on behalf of the school, but really aren't. They're just sort of carrying out activities on the school property with the school's blessing. So maybe in that sense, they are acting as some kind of agent for the school at minimum. But I don't know the answer to that. What do you think, James?
It's going to depend how it worked. So reading the Comic Book Legal Defense Fund article, which, I mean, admittedly is going to be a somewhat slanted source in how they present things, but it said that the administrators notified the parent-teacher organization and allowed the handful of parents involved to determine the fate of the book. So there you have the, and it said that normally parents aren't given the option to regulate what books should be included in the book fair. So in this case, the school, which normally has the power to determine the books that are made available, said, y'all decide. Well, I think they're still responsible for the decision made there. If what they'd said is, I don't know, let's ask the Magic 8 Ball. It's not like they can say, oh no, it's not censorship anymore because it's the Magic 8 Ball that made the decision, and that's not part of the government. No, I mean, when they delegate that responsibility like that, they're still the ones carrying out the result. If just because the PTO said no, don't carry it, there was still the school administration and thus the government that's carrying that out, that's saying, yep, indeed, we will not have it. They're still executing that decision.
Right. All right. Well, let us move on and get into the law and policy of the comic book universe itself. All right, James, these are all pieces that people can read more about on Law and the Multiverse, which is where we pulled these stories from. Some of them you're pointing out to other folks who have either posted at your blog or are folks who you're acquainted with. The wonderful piece here by Jake Littman, who I think has posted at your blog before. And considering, and I think this is fun as we are being barraged by presidential election debates on sort of a bi-weekly basis these days, to consider whether Thor is an illegal alien and whether he could be kept out by a wall, for example. Actually, I don't think that comes up in the piece, but everything else under the sun about Thor's the legality of Thor's presence in the United States or any other country in the world is unpacked here, including what sort of visas he might qualify for, and some citizenship considerations as well. Can you flesh this out for us a little bit more, James?
Sure. This is a problem that comes up anytime we talk about superheroes or supervillains, for that matter, who are aliens, who are literally extraterrestrials. There are two issues. One that Jake didn't address that I have elsewhere, and then the one that he did. The first issue is, well, Thor's not technically human, and our laws are aimed at people. So strictly speaking, someone trying to kill Thor would not be guilty of attempted murder. They'd be guilty of animal abuse at worst. But that's kind of another issue. The comic books and movies tend to ignore that aspect of things and just say, well, they look and talk and like humans, so we'll treat them as humans for legal purposes. So Thor arrives by the Rainbow Bridge. He's just sort of basically just teleports into the United States for all practical purposes. Well, that means that he didn't go through the normal immigration process, and he didn't present a passport or a visa as necessary, and he stays in the United States for a significant period of time that would potentially normally require some kind of visa if he wasn't from a country that lets you visit the United States for leisure purposes for I don't know exactly how long it is, but so many days, just when you're on vacation or whatever. So this is a real problem, and other characters have the same problem, like Superman, for example, on the DC side of things, is I think very famously, and that's one that the DC Comics have actually investigated a few times, considering, well, is Superman a United States citizen? If he is, how did he become one? And there's some interesting arguments that can be made about that. In Thor's case, though, there's no argument that he's a citizen. He wasn't born in the United States. His parents are not United States citizens, and he clearly doesn't go through any kind of citizenship process, naturalization process, at least not in the first movie. Between the first movie and later movies, maybe something happened. It's not clear. So Jake runs through, well, suppose they were going to try to get him a visa. What options would there be? Obviously, he's not necessarily doing the normal kind of process. He's a very different kind of person. So maybe he could be considered a head of state, or he could be an alien with extraordinary abilities. He could be a person in a religious occupation, and his role is the god of thunder. Who knows? There's various arguments that could be made. And I think it's a great article, which does one of the things we really try to do on Law in the Multiverse, which is not only geek out a little bit about comic book situations and tease out whether or not things are being done according to the law, or if not, why not, or maybe the law can be stretched or bent to make it work. But it helps explain the different kinds of visas that are available in the United States and the naturalization process a little bit. So it's a nicely educational piece as well, which is always a good bonus.
Yes, and we should continue that thread. It's useful to know, for example, that as Jake points out here, O1 visas are the visas available for aliens with extraordinary abilities, and that Justin Bieber is only residing in the U.S. Because he's qualified for one of those kinds of visas. H-1B visas are the kind that we're familiar with quite frequently in the technology world, where people have an advanced academic degree or equivalent and are brought in to perform professional skills in specific fields. Jake points out that Thor would need his Asgardian diploma and college transcripts, and he's skeptical that he'd be able to supply those. So it's really a nice piece, and as you point out, helps us better understand our own laws by considering them in the realm of Asgard, an Asgardian immigrant to the United States. Sarah, any thoughts?
No, it just strikes me that it's the type of thing they should do in law school more. I don't remember very many teachers doing this sort of method, but it is a really great way to learn it and kind of apply the law to an actual situation, even if it's not a real life situation, but it's one that most people are familiar with. So,
yeah.
A few law professors have written me letting me know about their use of comic book situations as hypotheticals, either in class or on final exams. So it's an idea that's gotten some traction to be a little more interesting than generic, O sells Blackacre to A, right. A gives B a life estate, whatever. Instead, to talk about comic book characters, which provide, sort of, it's just slightly naturally a little bit more interesting because they're people or characters that people recognize, but also they have built-in motivations and relationships. So it becomes sort of the scenarios write themselves, which is nice.
Right. Yeah.
All right. I don't know if this one would be useful for a law professor or has any sort of educational value whatsoever. Maybe you guys can help me find the nuggets of that. In considering the world of Harry Potter's Wizarding World's government and its relationship to the UK and the Crown. And that is something that you pointed to on your blog, James, and is quite fascinating as well, to consider what the Ministry of Magic is and how it may or may not interact with the British Prime Minister or Parliament. Can you flesh this out a bit for us?
Yeah, so Harry Potter is one of those things like the Lord of the Rings and Star Trek and Star Wars that people have asked us to write about on many occasions, but that I generally haven't, because Rowling is a great writer in many ways, but creating cohesive, fully fleshed out worlds is not her strong suit. So the world of Harry Potter as it's presented in the books is very evocative and interesting, but the details leave a lot to be desired. How does the economy even work, for example? There's a lot of things like that. So in this case, someone else wrote up a post about these topics in the Harry Potter world, and so I thought, well, if someone else is going to do the work for me, then I'm happy to point that out. And I think that the main thing that she ran into was the same problem that I had with the idea of it, which is that it's just really hard to know. It just seems like such a mess. It's hard to even know where to begin. So, for example, I don't know exactly how it works in the UK, but I'm pretty sure that they have educational standards in their schools that even private schools, which confusingly in the UK I believe are called public schools, have to make sure that certain topics are taught and that children receive a certain minimum education, regardless of the particulars of the school. Well, we hear an awful lot about the Harry Potter and his friends taking classes on magical stuff, but they never take any standard courses like English or, for example, which, even if they never have to take a single class on Muggle history, because what does it matter? We live in the Wizarding world now, and it just doesn't matter what happened in the Muggle world after the wizards sort of retreated into their own world. They still need to know how to write a decent essay. Certainly, they get assigned to write plenty of them. So there's some things like that you see classes on numerology, but not, or arithmancy, excuse me, but not basic, just ordinary math, which again seems like the sort of thing they might need to know. So even in a Wizarding world.
That's right.
So I think that one of the interesting things about it is just that it's more of a big long list of why things don't necessarily make sense. It's hard to know where to start in terms of tying it to the real world again.
Right. The author here spent some time considering the extent to which the wizards who are messing around with muggles could be guilty of crimes against them, such as assault or goodness knows what crime when you're erasing their memories. And then one of my favorite things she brings up is criminal law aside, the fact that the children who go to Hogwarts and leave the Muggle world to become wizards just sort of vanish from, the world as we know it. And she writes, does no one ever notice that all these people's paper trails have dead ended? So it's definitely a fun thing to consider. Sarah, any Harry Potter thoughts?
No, I'm ashamed to admit that I have actually never read any of the Harry Potter books or seen the movies. I know.
Oh my gosh.
I shouldn't
Come out
say
from
that
under that
public.
rock you've been living under.
Bad.
That's pretty funny. Is there a reason?
I'm just not that interested. I'm not a big fantasy person at all.
Mhm.
Like I haven't read I have seen the Lord of the Rings movies, but it's just not and same with my husband. So he doesn't force me to watch them. So we haven't. Maybe when my son gets older, I would read the books with him or something. He's only 3
Yeah,
right now.
you're going to have to send your son to me for some supplemental education at some point.
Exactly. We'll send him to California for the summers.
Yes. All right. The other interesting notion is, and I think you would probably say that the same is true of the Star Trek universe, James, that their legal system and justice system isn't all that well fleshed out, although it's there from the very beginning of the show, right? In the pilot of Star Trek, the original series, the way they brought the pilot into the series itself was to have a trial where Spock was on trial for what he did to Captain Pike. So it's always there in the background. They have various tribunals and things that take place throughout the show, but over at his customs law blog, Larry Friedman is wondering about all those times that the Enterprise is carrying cargo and dropping it off at planets and what sort of customs duties might apply. Can you tell us more about that?
Yeah. So Friedman is a customs lawyer who works on in that area professionally and has a great blog that just covers real life customs law, but occasionally has some fun stuff, especially in his rulings of the week, where he finds customs rulings on really strange products or just fun ones. And he found one on these little plastic badges that were as a cereal box toy, and they were imported in bulk and then sent to cereal packaging plants to be inserted in the boxes. And the badges were not individually marked with their country of origin, that made in China, made in Mexico, made in the USA, whatever thing that we see on all kinds of products. And the case was about whether or not that needed to be on there. But as he notes, the one oddity is that the badges are the wrong kind. The design is wrong for the series that they're supposed to be associated with. But anyway,
I love the Tony the Tiger Vulcan salute that's being shown if anyone's watching the video right now.
Yeah. So anyway, getting away from the details of that, he mentioned that he wondered if there were ever any cases in the Star Trek series about customs duties or imports laws or anything like that. We certainly see plenty of trade happening in the Star Trek universe, although the existence of replicators makes one wonder why that should be the case. But anyway, people do seem to spend a lot of time moving stuff around on cargo ships. And he wondered if that had ever come up. I was able to find some sites that maintain transcripts from all the shows, and there are a few references to import laws and bans and customs regulations and stuff, but not very many, not as many as you would think based on the number of times people find cargo ships. But yeah, there's a few. And that's a good example, though, of why it's so hard to write about Star Trek in universe, is that either they just don't talk about law very much, or when they do have something that's law-centered, like the famous Next Generation episode where Data is on, there's a trial to determine whether or not Data is a person or merely a thing. The problem is that there's not enough. The legal system isn't fleshed out enough. It's hard to say whether or not they were following proper procedure, or whether or not the decision made sense from the point of view of Starfleet regulations or Federation law or whatever legal thing should apply, because we don't know what those are. It's not like things that are set in approximately the modern day and approximately the real world, where we can say, well, they're going to be using regular old United States law, so we can look that up.
Right. Let's make "Is Data a Thing?" our second MCLE passphrase for this episode of This Week in Law. We put these phrases in case you are listening to the show for continuing legal or other professional education credit. This might not be the show to submit. This episode might not be the episode you want to submit to your oversight body, with the exception of our discussion of the Kimball versus Marble case and the censorship cases. The rest of this is kind of distantly far afield from what I think an MCLE accreditation board might want to see coming in their door. But our various other episodes, I think you should feel free to have at it. And we've got a list over at wiki.twit.tv that has a breakdown of all the 50 U.S. jurisdictions and how you might go about applying for credit for watching or listening to the show. And we put these phrases in so that you can show that you did just that. If you know the phrases, that means you found them and you actually watched or listened to the show.
I will note that I have actually done several proper CLE courses using comic book examples, including some ethics ones. Those are some of the most popular ones, as they often are in many jurisdictions. There are several superheroes who are also attorneys, like Daredevil and She-Hulk, and so it's often very fun to look at examples of them doing their lawyering and then say, well, what's wrong with this picture? Why is what they're doing probably going to get them disbarred? And so it's actually possible to make, really, I think, fun CLE classes that use comic books as a jumping off point, and then get in quite a bit of detail on the legal part. And those have been a lot of fun to do.
Absolutely, and that's what Sarah was bringing up before too. That there's a definite way to use these universes educationally, and that's something we're going to discuss in just a second as we begin to wrap up the show here. All right, you also pointed to this on your blog, James. This is by Thomas E. Simmons. What zombies can teach law students, and it's exactly what we've been discussing, using the whole notion of zombies and what havoc they may wreak to teach various real-world legal principles, including, surprisingly enough, estates and trusts is one of the examples given in here. The author writes, as an assistant professor at a law school, I occasionally sprinkle references to zombie narratives in place of the standard players A, B, and C. For example, to illustrate President's interest concept for annual exclusion gifts in trust, I display comic book representations of key characters, provide their names and relationships to one another, then outline a scenario from The Walking Dead where Rick Grimes makes a gift in trust to Shane Walsh as trustee to pay Rick's wife, Lori, for life, remainder to son, Carl, et cetera, et cetera. So there are all kinds of ways you could use this productively to get across actual legal concepts. And he also touches on the point that you raised concerning data. Again, how I suppose this would be helping people understand the interplay between laws that apply to persons and those that apply to animals and those that apply to property. He does a whole scenario here about whether zombies are entitled to various fundamental human rights or not. And this is something that's come up on our show before in talking about artificial intelligence and what ultimately, how we ultimately treat these artificial life forms that will be among us at some point. So, James, what else did you want to point out about this?
Well, I think it's interesting because this is actually at least the second law review article focusing on using zombies as a jumping off point to talk about legal principles. And I think it's cited in the Simmons article, but there was another professor from Arizona State University, Professor Adam Chodorov, who wrote about death and taxes and zombies, where he asked the question whether someone who becomes a zombie should be considered dead for estate tax purposes.
That's right. We've featured that on the show before, I believe, in one of our Halloween episodes.
Yeah. So it's interesting to me that it's not only in and of itself, but also that it's the second in, I guess, a genre. And there have been others written about other topics. For example, the depiction of lawyers in comic books. There was a great article that rather exhaustively considered every single example to that date of a lawyer being depicted in a comic book, and that person actually developed a citation format for citing comic books in law journal articles, which is the format that we followed in the book, The Law of Superheroes. But as far as the Simmons article itself, I think he makes the great point that these more interesting pop culture scenarios, while on the one hand they may seem lightweight, kind of puffy sort of ways to talk about the law, actually can do a really great job pedagogically of capturing people's attention, and they can act as a shorthand. When you say A and B, like A shoots B, well, that's boring, and people really have to think hard to care. But if they say the Joker shoots Batman, well, they immediately know who the Joker is and who Batman is, and they know why they would do that and that kind of thing. And it can be a great shorthand for talking about legal situations. And if someone doesn't know who the Batman or Joker is, then in some ways it's no worse than A shoots B, except that you've given them sort of interesting names, I guess, which in itself is good. So I think that
if you must use A and B, at least A should be eating B's brains. Yeah,
exactly. Why does it have to do? What does it always have to be shooting? It'd be a little more interesting than that. So yeah, no, I think he makes some great points, and I think it's something that personally I'd like to see more of. Not necessarily that all law classes ever have to somehow be based on comic books or pop culture, but I think that as something to use from time to time, it can be a good teaching tool.
And James,
Sarah, maybe they could be used to explain Creative Commons licenses.
Zombies? Yeah, that would be really cool, actually. James, I was going to ask you if you said law professors have contacted you. Did they contact you to tell you that they created their own scenarios, or that they used yours in class, or both?
Largely to mention that they'd created their own. Okay. I think that I don't usually post things that are questions without answers. So I think that they would probably not want to use things that I'd written because my analysis is already right there. So it'd be pretty easy to cheat it, I guess. But yeah, no, several. I think it's 4 or 5. I think have mentioned using something like this in their classes.
That's really cool.
Yeah, you could get into all kinds of things with zombies, whether they're more of a disease than a person, and regulation of disease, and it's a very funny piece. I encourage people to check this out. So speaking of questions without answers, our technical director, Victor, may have one for you, James. Victor, you want to run it by him?
Hey, James.
Hi.
So I was telling Denise earlier, I like to read just like you. I'm a big comic reader and stuff. So I have a lot of old books and stuff that I like to go back to. And I came across one from the 80s that was like a Marvel team-up book. So it was Spider-Man and the Fantastic Four, right?
Sure.
So something happens to Spider-Man. He has to ask Mr. Fantastic for help because somebody's taking over his mind. On one page in particular, there is, and I couldn't find it online, otherwise I would show it, but Mr. Fantastic is basically analyzing Spider-Man's brain to find out what's wrong with him. He can't figure it out, so he gets on the phone and calls Professor Xavier. This is all on one page. And I was telling Denise, this is something so far from being realized in the new movies that are coming out and TV shows. And who do I have to be angry that this is not happening? Is this copyright law or is this like...
Well, it's not copyright law as such. It's more its particular application with licensing that Marvel licensed one set of characters to one studio and another set to another studio, and it worked in weird ways where they would license some characters and then ancillary characters, related characters, and there's some odd overlap. The best example of this is the Scarlet Witch and Quicksilver, who were licensed both to Fox as Fox's mutants, and then they were also in-house with Marvel's own studio, or licensed to Disney, and then Disney bought Marvel. But anyway, that's why Quicksilver and Scarlet Witch are in both the Marvel Cinematic Universe movies, the Avengers movies, that world, but they're also in the X-Men Days of Future Past, or at least Quicksilver is, and so that's it leads to some really weird situations. Although, of course, in the Marvel Cinematic Universe, there aren't mutants, so they're sort of the origin of their powers is explained in a different way. It's all very strange. But yeah, no, I wouldn't be mad at copyright law as such. I would be mad at the licensing practices of Marvel. It leads to some weird situations where usually the way the licenses are written is that you can use these characters for a movie, but you have to make a movie within X years. And if you don't make a movie within X years, then you lose the rights to the characters because we want to sell it to somebody else. Somebody's actually going to use the property and make us some money. If you do make a movie, then you can make a follow-on movie within so many years after that, and then another movie within so many years after that, up to 5, 6, 7, however many movies the deal is for. And several times now, there have been cases where movies were sort of pushed out the door, sometimes filmed with almost no budget and very quickly, just to fill the terms of that license, so that they could then keep a hold of the characters. There was a Fantastic Four movie made that way that was really, really terrible, but it wasn't made to be a good movie. It was made just to secure the rights for another so many years. And the most recent Fantastic Four movie, while it had a large budget and was, well, it wasn't great, but it was okay. Was made under those same kind of terms, that it was the license was about to expire, and so they went ahead and made a movie. They put a little more thought into it than the last time they did something like that, but not a ton. So that's sort of one of the problems with those kinds of deals, is that people exploit the terms to string things along when maybe they should have just let it go to somebody else. So that's one of the reasons why things have stayed so fractured, unfortunately. So I think Fox owns the rights to the Fantastic Four and mutants and a couple other things. I saw there's a chart I saw online that sort of showed the Venn diagram of all of who owns what, and it's a big mess. So
the short answer, Victor, is it could be don't despair. It could be negotiated.
Yeah.
Well, I somehow knew that answer, but it was I just was wondering if there's some way that they can get it together. Which hopefully with this Spider-Man deal with Sony and Marvel, it happens. But as a funny aside, me and my kids were at Disneyland recently, and they have, like, as part of the characters, they're having the Avengers as some of the characters in there, and we were taking pictures with Thor, and either my son or myself, we had an Avengers shirt, and Wolverine was on there, and so the guy playing Thor there, he was like, "Who's that?" And it took me a while to go, "Oh, you're good."
Never heard of it.
So they play around with it there too. So
that's funny. Hey, James, I remember seeing a post about Guardians of the Galaxy on your blog, and you saying there's not too much to talk about there. Couldn't we talk about prison reform maybe, or the lawlessness of the place that they go that's supposed to be the skull of the deceased alien?
Yeah. What question did you have in particular? I'm not really sure.
I don't have any particular question. I just want you to write about Guardians of the Galaxy because it's so fun.
Yeah. No, I wish there are often cases where I wish I could say more, but especially with Guardians of the Galaxy, almost all of it happens off planet. I suppose you could say whether or not it was okay for Star-Lord to get abducted.
Yes.
Well, in the first place, child custody issues with the death of his mother. Yeah, apart from that, I don't know that there's necessarily a lot to talk about since almost the entire movie happens off-world.
One of my favorite Halloween costumes, as all the videos of the great Halloween costumes and pictures were making their way around this year, is one that was on Imgur. I'm sorry I didn't cue this up before the show because I didn't know that it was going to come up, but maybe Victor can find it. That is a homemade costume of Rocket the Raccoon that is pretty amazing. Again, not for commercial purposes, not for sale, so I don't think the crafty parent who put it together would be in any kind of copyright or licensing issues. And it could be any, there we go, there's our rocket. It could be any two-legged, gun-toting, orange jumpsuit wearing raccoon, really, when you think about it. Right, James?
Yeah, maybe. Disney is not quite. It's going to be interesting to see what Disney's acquisition of the Star Wars property is going to do to its traditionally pretty sour look at a lot of fan stuff. Lucasfilm itself, for a long time, had a really permissive view of fan products. As long as you didn't sell it or try to make any money off of it, they really didn't much care if you wanted to dress up as a stormtrooper and make movies or whatever. That they felt that was all good fun and only made people's interest in the products all the greater. Disney's kind of known for being pretty harsh about their IP. And I will say that when just before The Law of Superheroes, the book came out, we didn't get any letters from DC, but we got a letter from Marvel, from their general counsel, saying, we became aware that you're planning to write this book. Just be aware that if you violate our IP when you do, that we'll not hesitate to enforce it.
Wow. Shot
Luckily
across the bow kind of thing.
Yeah. Luckily,
they had no idea what was even in your book at that point.
Yeah. Luckily, our publisher had also published The Physics of Superheroes, a book, similar kind of idea of explaining physics concepts with examples from comic books, and had done the same thing of including illustrations from comic books. And they'd gotten a similar kind of demand from Marvel. The Marvel said, well, you used so many images taken from our comic books. I don't remember exactly how many. Let's say it was 40. So pay us $40,000. And the publisher told them no, and that was the end of it. So in our case, I don't. As far as I know, Disney never even or Marvel, I think that predated the merger, never even approach us about a specific amount after the book was published, but they definitely sent us a little warning letter. So, they're known as being kind of tight-fisted with their IP, and it'll be interesting to see how that changes or doesn't, especially with regard to the Star Wars properties in particular. But I think that more and more companies are realizing that cracking down on fun stuff like that in the age of the internet, where by the time you become aware of it as the IP attorney, 1 million people have already seen the really cute Rocket Raccoon costume, and if you try to do anything bad about it, you're only shooting yourself in the foot. It's just a giant PR disaster to try to say, oh, no, you shouldn't do that. So it's something that I think more companies are becoming a little bit more understandable about.
Right.
Yeah, that's true.
Sarah, anything to add to that? There are a lot of fair use considerations about using comic book properties in books or documentary films. I think we own that Physics of Comic Books book. And there's also another one that's sitting in the next door bedroom here that's about obscure superheroes in comic books that you've never heard of before. That's really, really funny. And again, they have to use all the old imagery in order to bring the book alive.
Right.
So any thoughts about that?
Well, I'm kind of fascinated by your publisher just saying, no, that's awesome. Who published your book?
So it was, hilariously, it was Gotham Books, a division of Penguin, which was very funny to me, that we were writing about comic books and Batman a lot. That was very funny. But yeah, no, they were the publisher, and they didn't have too much trouble with it. I mean, if there was a lawsuit, the terms of our publishing contract would have put it on us as the authors. We would have been the ones defending the suit. There was a part of the contract was an indemnification agreement to the publisher for IP issues. But I felt pretty good about the fair use arguments that we were taking single panels, or at most one or two or three panels in a row from comic books. They were in black and white, not in color. And they were being used for an educational purpose. The only thing that, of the 4 fair use factors, the only one that was really a strike against us was, well, I mean, we were selling the book for money. That's true. But it was a small piece of the larger, very small piece of the larger work. It was, made black and white, and often even shrunk down some. And it was done with for an educational or commentary or criticism purpose. So I felt like we had a pretty good argument. I don't think anyone would think that would reasonably think that the market for these comic books would be affected negatively by the existence of our book. That they would say, "Oh no, I don't have to buy that comic book because I already saw one panel in this other book, one small black and white panel in this other book." So I think our fair use argument was pretty good, I thought. So I wasn't too terribly worried about it.
Right. So is that part of what's your day job? Like your normal practice? Are you a copyright? You said patent too, or do you do a lot of? I do some intellectual property work for some clients, but actually by day I'm an academic. I worked for the Stanford University Hoover Institution's project on commercializing innovation for 6 years. That was sort of a intellectual property think tank, more or less. And now I work for the Center for Empirical Research in the Law at Washington University in St. Louis, where I do empirical research in the law. So that's what I do during the day for the most part. I'm an attorney, and my private practice is IP. Oh, really interesting.
Yeah. All right. Well, I think we're ready for a couple of a tip of the week and a resource of the week that are right in keeping with everything we've been discussing today. Our tip of the week is aimed maybe at particular schools in Michigan or wherever you might run up against people not wanting your children to read comic books. It's a piece by Creed Anthony called 5 Reasons Your Students Should Be Reading Comic Books. So if you, are having trouble justifying why comics are a worthwhile literary endeavor for young people to engage in. It's a nice summary of various points, including that they're interesting, the kids want to read them, that they incorporate many different elements of fiction in short pieces, that they have all kinds of different genres. So there's all kinds of variety there. I like this one, that comics are like the Twitter of novels. Because limited space in each panel requires you to choose the best words to tell the story, and that they serve as a connection to history. So if you are looking for a good way to justify children's reading of comics, it's right here. And I would just encourage folks, it's however you can get kids to read is a good thing, whether it's comics or manga or whatever interests them. I'm just really, really happy whenever my kid has a book in his hands. So the Guys Read series is also amazing on that front. Our resource of the week also was featured on James' blog, and it's a piece from the University of New Mexico School of Law. Actually, their entire spring volume of the Law Review was about the law of Breaking Bad. So a whole host of articles about Breaking Bad in the classroom, I assume, is something along the lines of what we've been discussing about using zombies to spice up your hypotheticals. Various specific situations, again, focusing on lawyer ethics with Saul, Better Call Saul, if you want discoverable communications, the misrepresentation of attorney-client privilege on Breaking Bad, and various other legal issues that are pulled out from the show and analyzed. Anything you want to add to this, James?
No, I would really recommend that Law Journal article. It's not about comic books, and so I didn't say much more than, hey, check this out if this is the kind of thing you like. But it is really great, especially obviously if you're a fan of the show. But even if you're not, even if you didn't follow it much, it's a really neat article. It's a really neat volume with some really great articles.
Yes, covering things like deceptive police practices, how the war on drugs and public antipathy constrain women of circumstances choices. It's pretty amazing what they've done here. Did you take a look, Sarah?
No, but I was going to say this is one I would have actually been able to. I loved Breaking Bad, so I would have been able to weigh in on. So we should have an episode on that sometime.
All right. I will better call Saul to be on the show, I suppose. All right, folks, this has been super fun. Thank you so much, James Daly, for joining us once again on This Week in Law. Other than running out and buying your book and continuing to go to the panels where you're discussing the kinds of things we've talked about on the show today and reading your excellent blog, anything you would like to let people know about?
I don't want to say too much about it, but we've done some really fantastic research here recently that hopefully should have big news about it being published in. Well, it's hard to say. The publication timeline is pretty elastic, but in the next few weeks or a month or two, hopefully we should have some good news about it being published. But we've done some I think really interesting research about the Supreme Court that I think a lot of people will be interested in. So.
Oh, cool.
So hopefully have some interesting day job announcements.
Please keep us posted when it comes out, will you please?
Sure.
Okay. And Sarah, great to see you again as well.
Yeah, great to see you. It's a fun show.
We'll have a pre-recorded show for you next week that is all about cars, automotive technology, transportation technology, and the law. So we encourage you to join us for that. And then we'll be back again live the week after. If you're joining us at 11 o'clock on Friday, that means you've been watching us record the show live. We do that at 11 Pacific time, 1800 UTC every single Friday. So if you've been able to do that, thank you. We enjoy having a live audience. But if you can't join us live, don't worry about it. If you head on over to twit.tv/twill, that's where our entire archive of shows resides. And you can dig into the archives to your heart's content. You can also find us on Twitter and Facebook. Sarah is S. Hinch Pearson on Twitter. I'm D. Howell there. There's a This Week in Law page on Facebook and on Google Plus, and a community over on Google Plus as well, where you can interact with us between the shows at greater length. We'd love to hear your thoughts about what we've been discussing, who we should have on the show, what topics we should cover in the future. All of that is really, really helpful for us. So please get in touch. You can also email us. Sarah is sarahp@twit.tv. I'm Denise at twit.tv. And we look forward to hearing from you however and whenever you'd like to give us a shout. Thanks so much for joining us today. And we'll see you next week on This Week in Law.